Welcome, welcome, welcome. So for our meeting today, Randall's not going to be with us, but we're going to go over family estate docs. So we're going to start from pretty much the beginning and go through the entire process to cover, especially for new people. The way that I've set it up is the phone calls that I'm receiving. Hey to everybody. I see we got Joseph and Mike and Don. I see Ed popping in there. Hey, Tony. Hey, Raina. All right. So as we go through it, if you guys have any questions, definitely put them hit those questions. We'll answer every question that you have. So you can actually put it into the chat or stop me and I will answer them as we go. I have no problem doing that. So what I'm doing is I'm going to do a screen share with you. The first thing we're going to do is we're going to go to the familyestatedocs.com and we're going to send somebody a trial. So this has been a big question. Everybody's asked me, how do I send a trial? Now, if you already know this, awesome. You're already kind of ahead of the curve. So what you're going to do is you're going to just hover over the sales tab, go down to free trial, and then you're going to click on the free trial. Now over here, we're going to put in your client's name. Now mine is a cowboy. And then you're going to put in the address, of course. Now the length of the trial that I typically do, I want to be back with them within 2 weeks. So I do a 14-day trial. I think that that gives them plenty of time to check everything out, and it also is still enough time where the iron is still hot, because you know we always want to strike while the iron is hot. And now this is going to come to your email, and it is absolutely 100% okay for you to go in and change the password. So you see that his username is going to be his email address. And then this is the temporary password right here. So what we want to do is we want to take that temporary password, copy it, click on your familyestatedocs.com, and then you're going to click sign in, but you're going to sign in with that email address that they just gave you, which his was kcollinscowboy@gmail.com. And now this is where we're going to go ahead and copy and paste that password in. Now the first thing that it's going to ask you to do is it's going to ask you to accept the license agreement on their behalf, and that is okay. So we do want to accept that license agreement. Okay, now it's going to ask you automatically to set them a new password. Now this is super easy. We're going to simply use the digits of his address, which was 231, and then we're going to use the street name. Now I am a capitalization freak because that's my personality. I know if it's a proper noun, a name or a place, it's going to have a capital. If capitalization is not something you care about, do it in lowercase. But for me, if I'm going to remember it, I have to capitalize that first word. So his password is now 231 Roberts. Okay, and so we're going to go ahead and change that password. Now, like I said, if you will not remember a capital letter, make it lowercase. This is for you because you're going to be the one that's going to go in and create this document. And now I know he's not married, so we're going to make him a single grantor. and create the trust. So you have now created your first trust, and this one right here is for Tyler Collins. Now on the interview part, when you click on interview, you're simply going to start going down the list over here. This is the welcome. This is his personal information. Now hopefully he gave you most of this in the confidential when you sat down with them, either on Zoom. Some people are doing it on Zoom, some people are doing it in person. So all of the information that is here is going to be from the confidential. Now I'm going to pop back over here because I want to show you guys what the confidential looks like. This has been another question, and if you already know, that's awesome. So this is what the confidential looks like. This is your confidential. Right at the top of it, that's what it says. All of this paperwork can be printed off right from Family Estate Docs. If you need it, print it, make a folder out of it. So when you sit down with them, you can either do it on the computer as you go, or you can fill one of these out while you're sitting there. And then when you get home, you sit down and transfer everything that you actually got in the confidential, and you're going to put it into Family Estate Docs. So let's go back over there and take a look. Now, this is where you're going to fill in some of the stuff that was missing. So he's in Sevier County, Tennessee. And now it will always tell you, do you see right here where it says that the highlighted areas are required? That means I've missed something. So over here, I want to make sure I document that he's a male and a U.S. citizen. Now we'll hit save. All right, so then you're just simply going to start moving it down. The trust name, this is very important. Once you name that trust, that is the name of the trust. This is one of those things that you can't go back and change after you printed it without doing a full restatement. You don't want to do that. So for this trust, he named it Now we have had some all kinds of funny named trusts, so they can name it whatever they want. We've had
Question.
Yes.
You said that you can't change the name after you print it. Are we able to change? Basically, if you save the name right here, right now, and you don't ever actually generate a document, can you go back and change that name, or is it once you fill this line, it's fixed?
Now I have not tried to go back and change it once that line has been filled in. I do know that once you generate it, it becomes permanent. But see, it says right here, make sure that you're comfortable with your choices, because these choices become a permanent part of the estate plan once it's saved. So I'm gonna say where it says save and continue, once you fill that out and hit save, we'll go back and try and see, because this is actually for my son. And so it's not, it really doesn't matter. I just wanted to try him kind of just to show you guys what it works as. And then the date is another very important thing. If you sat down and did this on July 10th, you're going to date it July 10th. If you're going to date it for today, you can actually do today's date on it. So I'm going to go ahead and do today's date on it. And then we're going to try and see if it will let us go further and then go back and change the name of it. Now, the beneficiary shares, this is something that you can definitely go back and change if you see that you have made a mistake and they all want to go equal, or you get a family that says, no, I'm taking care of my youngest son all the time, and my oldest one I never have to put money into, so I want my oldest one, to have a different share. You're going to want to click no, that you want to determine the size of the share for each beneficiary. But if everything is going to be equal, you're just going to click yes. And now this, do you want a single individual or organization to serve as your trustee and executor with an alternate, or do you want to set up a committee of co-equal successor trustees? All right, so you've got two children who are going to fight like crazy if for some reason one of them is the successor trustee outside of your spouse. You can create a committee, which say you've got a blended family. She has a daughter and he has 2 sons, and you want a representative from both sides of that so that if something happens to her, he can't cut her daughter out. If something happens to him, she can't cut his son out. So you might want a committee on that so that that gives them peace of mind. So they'll have a representative come from the mother side and a representative come from the father side. Does that make sense? All right, so we're going to assume one successor trustee, and then we're going to hit save and continue. And we'll go down here. He does not have any children. Now, if they do have children, this is a really big deal. If you have a joint trust for children, you're going to want to put in here ages and stages. If you're not concerned, or if your customer is not concerned about how old they are when they distribute the funds, you can just click no. They can have it at any age. However, if you want them to distribute it in stages, like they might get 25% on their 18th birthday, wait till they're about 21 until they get another 25%. Wait till they're about 25 until they get the other 25%, and then 30 till they get the rest. Or they might have some for college. They might want to distribute some at when their first grandchild gets married. They might want to distribute some when they buy their first home. That is what all of this is for. If they're still in school, you might want to allow them early distribution for extracurricular activities. So if your granddaughter's a cheerleader, this would give her money to afford her uniforms. If you want to match a scholarship, if she applies for college and she gets a $10,000 scholarship, you might want to do an early distribution to match that scholarship for her for college. Education expenses, same thing. Do you want an education expense, but only if they have a particular GPA? You can actually document that in here. What about for health and medical needs? Do you want to allow expenses for those? Do you want to withhold distribution if that specific child is addicted to drugs or alcohol? So you can say, yes, don't distribute until they're clean. And at that point in time, if you do click that, you can also put in there that they can have $500 towards rent each month. So you can have the trust put what that specific child needs instead of just handing them a lump sum of money that will just contribute to their addiction. Do you want to give them an early distribution for wedding expenses? What's the maximum amount that's going to be covered for that wedding? For their first home, for a business startup, or for church missions if they want to do a mission trip with their church. So these are all of the different options that they can decide for their children or for their grandchildren. This next one is roles. I get at least 2 calls a week asking me, what's a financial agent? What's a successor trustee? How come I have to have a successor trustee if I already have a trustee? This explains exactly what role responsibilities with each one of these. So this tells you what the trustee is. So you know that the trustor is the person that owns the trust. Well, typically, while the trustor is still healthy, they are also the trustee. So the trustee is the one who controls and manages the trust for the benefit of the beneficiaries of the trust. This person can move, sell, buy, or dispose of assets. Initially, the trustor and their spouse, or the trustor if they're not married, will serve as the trustee until they decide they don't want to do it anymore. There's 3 reasons that a person may decide to no longer be the trustee. And that, of course, is a change in health, or two doctors say that they are unable to provide that responsibility anymore, and then it will go to the successor trustee. Or if a judge rules that that person is no longer competent and able to handle the responsibilities of trustee. So if one of those three things happen, that is when the successor trustee comes in. This is after their death or after one of those three things has happened. At this point, the trust becomes irrevocable. So the successor trustee must follow all of the directives that were provided by the trustor and to administer the estate, pay any debts that are in there, distribute assets. If any distributions are held until heirs reach a certain age or conditions, the successor trustee is also responsible for managing investments and paying ongoing expenses. And then, of course, there's a healthcare agent. This is the one where we fill out the durable power of attorney for healthcare, and it gives this person responsibility literally for making those life and death decisions about the healthcare of the trustor. So this person must be an adult. Do not let them let their 10-year-old be their healthcare agent. Same thing with the financial agent. You want that to be an adult. So this is a durable.
Question about the trust. If a judge rules that you are not fit to be the trustee, is that when it's conservatory trust?
Well, that's when it's passed down to the successor trustee. And that's even with this trust, the revocable one.
But I had a question proposed to me about a conservatory
Okay, let me check
trust
and
or trustee.
let me look at that really quick for you. Sorry, some of the things I'm having to look up myself, so. Okay, so the conservatorship is basically a legal process that will appoint a person to manage the finances of someone who is incapacitated. Now, you won't have to have a conservatorship in this specific trust because you have the successor trustee you've already chosen. If a judge has to put a conservatorship, that means that you didn't have it set up to begin with.
Okay. All right.
So basically, when I looked at the overview of it, it says that it's a legal process that will have to appoint a person to manage the finances of someone who is incapacitated or unable to manage their own affairs, while a revocable trust takes care of that for you, and it allows a trustee to manage those assets.
Okay. Thank
Does that
you.
make sense? Did that answer
Yes.
your question? Okay.
Yes, because they also wanted to know that with family estate docs, would conservatory trust, would we need to be concerned about that?
You wouldn't have to have a conservatorship because you would have a trust successor trustee.
Okay, thank you.
Yeah, that actually saves them money because that what you're speaking of happens when somebody has to go to court over somebody passing away, and then everything goes into the court system, and then the judge decides. So with this, you don't have to worry about that.
All right, thanks.
All right, now let's go back over here and see if it lets us change the name of our trust right now.
While you're going and doing that, what resource did you go to answer Eddie's question?
I literally just picked up my phone and clicked on Google, and I just put in
Okay, that's good.
what's the difference between a conservator and a basic revocable trust, and it just kind of gives you the difference and the purpose and how it works.
Super. That's fine. I didn't know whether if we had some specific resource document in family estate that I wasn't aware of, but that's fine. Thank you.
Oh yeah, no problem. Okay.
I have a
Ms.
quick
Freeman?
question. Can you
Yes,
hear
ma'am.
me?
Uh-huh.
I know that we said during the free trial is that how we go every time we're starting a new trust, is go to the free trial sales, or is
Not
there another way
necessarily.
to, okay, what's the other way without doing the free trial?
Okay, so the other way without doing the free trial, let me log into my own family estate docs. And we'll pull out of the one we were in. Can you guys see my screen?
Yes.
Yes.
Right.
Yes, we can.
Perfect. Okay, so hover over your sales tool and click on client sales. And now this is where, now out of the free trial, they can also purchase through there, but this means that they're ready to go. And then this is where you would just go ahead and put all of their information in, their credit card information, and click purchase. This over here for the referral codes, if you're going to do a discount for somebody, there's a place that you can go and get your referral codes. You can also go down here and view all of your customers. And this is a client demo. Kind of let them feel the customer experience before they purchase if you want to do that. I've never used this. I feel like explaining it myself works best for me. Under marketing, this is where you're going to find your promo codes. So if you click on promo codes, this tells you exactly what code to use for what you're going to, like if you're going to purchase your own trust and it's for you in your name, not for anybody except you, you can put secured 695 in there. You will not get paid on that trust. However, that will give you the discount for it. If you're just doing a discount for one of your customers that you've already had for years and you just want to save them a couple bucks, this is the codes that you'll write down. So if you want to make their trust $18.95, you're going to put capital $18.95, and that's over here in your client sales. So do you see the promo code right here? This is where you'll click and you'll put in that promo code. And then as soon as you put it in, you apply the code and it changes the price. So say that you want to do your own personal trust and you're going to do secured 695. You'll go right here and you'll put secured 695, apply your code, and do you see the final price here? That shows that you're getting a $1,300 discount, and then you'll fill out all of your information. You have now purchased your own trust. Now, I definitely recommend if you do not have a trust for yourself, it's kind of like a therapist, a divorce attorney, or a divorce therapist trying to counsel people trying to get a divorce and they've never had a divorce. So I always recommend getting your own trust. If you're going to be out talking to people about trusts, it's usually a good idea to be able to have your own as well. I know I just jumped into mine about a month ago and it opened up a lot. Even somebody who has been marketing trusts, I learned a lot about my own family estate plan by doing my own trust, and it's helped me immensely over the last month working with my own customers, because now I was very familiar with what things I had to go over because I did my own. Any questions about your
One additional question on top of that. Now, some people want a revocable and an irrevocable trust, like they have like two houses that are paid for that they want in an irrevocable trust and everything else revocable. Is that something that we do together, or is it two separate plans?
Okay, so over here, there is you can definitely put as many deeds in here. The deeds are $350 per deed that they're going to put into their trust. Okay, so let's keep on going and we'll get to that part. look right here. I'm not putting in as much information. So what happens every time you fill out information, it changes what's going to happen as you go down the line. So I'm trying to look and see where the revocable and irrevocable parts are. Let's look at the trust provisions. Okay, now do you see how the name, I don't remember who asked me, but if you can go back in and change the name, after I hit save, it is set. I cannot go back and change the trust name, and I cannot go back and change the trust date. So once you name it and date it, it's done. The only thing you can change is basically the beneficiary status and whether you're going to do one successor or a committee. All right, and so let's add, we'll put just this in here. Not disabled. Now, if you have an adult that's disabled, you're going to want to click yes here. So a lot of people will have somebody that they're taking care of that is an adult that is disabled, and they're going to have a caregiver for that adult because they have been the caregiver. So we want to make sure that if they do have that situation, that you mark yes and help them choose. You don't have to help them, but you do want to make sure you put their choice of who's going to take care of that person in their trust. Now I'm just putting numbers in here.
Excuse me, do you normally fill this out with the client or let them do it by themselves?
I do it with them. In fact, I do it for them. Everything that I'm doing right here is what I would do without the client sitting in front of me. I do everything on paper in front of them so that I can fix anything that we have issues with on paper. And then that evening or the next day, I'll sit down and put it all in. And then after I get everything in the system, I will send an email to the client with their username and their password and tell them to go through and become familiar with their new estate plan. And I can go through it with them over the phone, or I can let them do it. And I will tell you, a lot of times they don't even go look. They just depend on you to do it.
And we
So
pay our own plan, correct, if we do one, even though we're a licensee?
I didn't hear.
I said if we do our own plan, we're still paying for that, even though we're a licensee?
You get the biggest discount. You'll get yours for $6.95. That was the one that I showed you. And so instead of paying $19.95, you get basically the attorneys that wrote the software. You're pretty much just paying for your own software, and it lasts forever, just like everybody else's does.
And it win, but depending on how people join, if someone joined with the monthly, they're gonna have to pay the $6.95. But if someone, like actually purchased the initial license at like the gold level or platinum level, that includes a trust. So it really depends on how you joined and became an associate.
Okay. Well, see, Tony has a little bit more information than I actually have. So there you guys go. If you, depending on the level that you join, you may have a trust in there. When I came in, I had to put my toes in a little bit at a time. So I had to pay $6.95 for mine.
Thanks, Tony.
when can I ask you one thing? I'm just curious, how much of the trust do you fund for the client? Like how far do you go? How deep do you go with them in terms of like, their vehicles, boats, I don't know, like business, or just do you do the homes?
I show them how to add their other titles and stuff like that in, which I'm going to show you as soon as we get to the bottom of the family estate docs. I'm going to show you where they can add all that in. If you want to get copies of it and put it in for them, you are 100% welcome to, or you can show them how to do it themselves. And that way, if they do sell their boat and buy a new boat, they know how to take that old title out and they know how to put the new title in. And then, of
Okay.
course, they're the ones that are going to have to go to their courthouse and have that retitled in the name of their trust And that's something they don't have to do. People that buy and sell a lot, that have a lot of money, that don't hold on to their vehicles and their boats forever, it may not be beneficial for them to put that into their trust. So it just depends on the situation.
But initially, do we ask in the first meeting when we tell them to bring their deeds to the next meeting? Do we ask them about the other titles, like the
You don't
cars?
have to, but you can. I always ask them when I'm going
Uh,
through the confidential, when we talked about the paperwork and the confidential.
uh,
I always flip it over and I always jot down what they have. And then I ask them, would you like to store your titles for your car and your boat and this, that, and the other? Would you like to store those in your trust? One good thing about that that makes it even better than a safe is if something happens, if your safe is stolen, if your house burns, all of your titles are protected in your trust that you can access from any computer. So it protects them. Does that make sense?
yes, thank you.
All right, so let's go back over to family estate docs and we'll keep going. So this is the beneficiary. And see, it will tell you anything that you're doing, it will tell you if you're not doing it right, and it will not let you go any further. So that's another reason why I always suggest getting your own trust so that you're going through it and you're putting it in. It's going to make a little bit more sense for you when you're doing it for somebody else. Now, this is where you can override and restrict distribution to income only. So if you have a joint trust for children, or you have somebody that is on drugs and you don't want them to have a 100% or a lump sum distribution, you might want to override the provisions for that specific beneficiary. So your beneficiaries are going to be here in your drop-down list. I've only added one, so there's only one option. No additional distribution limitations will be on this trust. Contingent beneficiaries, you can either list multiple contingents or you can return it to the trust for redistribution. Now, this is the reason why I think that it needs to be put back into the trust. If say that you have 2 or 3 contingent beneficiaries or 2 or 3 beneficiaries and one of them passes away, do you want that to go to that beneficiary's children and grandchildren, or do you want it to go to that beneficiary's spouse to raise the children? So there's several different ways to look at that, and you have to figure it out. So say that they want to give the proceeds equally to only the surviving spouse and the children. But say that you've got somebody who doesn't want it to go to the surviving spouse because that's not their blood. They want it to go directly to the surviving children of their beneficiary. That's called per stirps. You might want it to go there instead. So you would click on either return it to the trust and then it would get redistributed to the other beneficiaries, or you can have it just that specific Jeff's children would receive his share and it would be distributed to his children only, which would be his share. Does that make sense? Any questions on that?
So it all depends on the preferences of the client, right? We ask
That's
them.
right. That's right. And if they're not exactly sure, return it to the trust until they may change their mind. All right. We'll have to let the computer catch up. We are right in the dead center here where our internet goes out regularly. So the next section is called disinherit. So in my specific case, I adopted 3 kids that came from a pretty bad house. They were a SIB group of 3, did not have a home, so I legally adopted them. At 18 years old, every single one of them hit a beeline back for their parents. One of them is in and out of the hospital from car accidents and different things, from drinking, driving, and drugs. One of them is in and out of jail, lots of time spent there, and the other one is back with her mother. So honestly, I did not want everything that I've worked for myself and for my family to go to these 3 children. If I did not go in here and click on disinherit and add those disinherited children, first you have to add them as your children, and then you have to go in and disinherit each one of them. Okay, or at my passing, my son, who has been with me the entire time and does not drink and do drugs, would have had to split his inheritance with the 3 of them, which I know all of everything I've worked hard for would be spent on drugs. So I don't want that. So at that point in time, I went in and I hit disinherit each one of them to prevent them from being able to get a share of what I'm putting aside for my son and his children and my nephews that are doing the right thing, that I want to have a part in what I've worked for. So this is very important. And a lot of times people will leave them out. In fact, I did for years, because after they left, I was like, well, they weren't my kids anyway. I just tried my best, did what I could do for them. And Randall said, do you have any other children? I said, no. And then he said, no other kids at all. And I said, well, 3 I adopted. So he kind of had to pull it out of me. And then I realized that if I didn't disinherit them, I was going to be in trouble. So you may have to do that with some of your clients. Have you got any adopted kids? Have you got any kids that have lived with you that could decide that they're going to stake a claim on something at your passing? So that's what the disinherit is. If you have sisters and brothers, like you'll deal with some people that don't have any children of their own, but they have sisters and brothers that will step in there at their passing and say, hey, you know, I've got a share coming. If they do not add them in under people over here, if they do not add them here and disinherit them here, there's a very good chance that they will be able to get some of that person's estate. So we want to make sure that they disinherit anybody that they do not want to be a part of their estate. Trustee selection. This is where at this point in time, he will be his primary successor trustee.
Question. So you're saying that if you do not put anyone down, you still would have to list them and then disinherit them?
Yes.
Okay.
Yes, you want to make sure that that's done for anybody that you feel like will stake a claim in your estate. And when someone passes away, you'll see sisters and brothers and cousins, all people that felt like they were involved in that estate will come in to get what they feel like is their share of that estate, whether it's theirs or not.
But when, just to toss something out there, your specific case, because you had adopted those children, then you are, you know, basically, yes, your estate has a higher probability of something occurring. But one of the things that, you know, it's like when you're mentioning brothers and sisters and or mothers, you're actually referencing the intestate rules of the individual states. Once you actually put a trust into force, you are no longer intestate, because your trust is standing in and replacing the whole estate process. So I 100% agree with you on your children you adopted. I think you might need to do some more research about brothers, sisters, etc., because you're crossing lines over into the intestate rules and laws.
Yeah, oh, you could definitely be correct. I just know that we have a lawsuit going on right now. A lady passed away and her sister suing her children. So I know that it happens.
Hmm.
And that might be part of the estate that you were speaking of. However, I'm watching it unfold right now before my eyes. Her sister suing her nieces and nephews because she felt like she should have had a part in her sister's trust. So,
Wow.
I say that
Anybody can sue by filing whatever your filing document cost is in your county of jurisdiction. But that's one of the big things of the trust. If the trust has been done correctly, once it gets in front of a judge, the judge is going to basically two questions. Is this the person who initiated the trust? Were they competent at the time that they initiated the trust? And is there documentation of the fact that, what are their witnesses and notaries? And basically the case is going to have a very minuscule chance of getting past those three questions.
exactly. But I just did my due diligence and make sure that if they do have somebody in their lives that they feel like would do that to them, especially if you're raising it, if you've raised your little sister and she feels like she can, I don't know. I say do what the client wants. If that's what they want and that's what they need, just do your due diligence, go through the confidential, go through it appropriately, one page at a time, make sure that you get all that in there, and do not forget, if they do have adopted children that they are no longer taking care of, adopted siblings or anything like that, disinherit them so that they can not have to worry about that part of it. But I agree with you, Tony. That's probably got a whole different side of it. You guys will know I know a lot about family estate docs. I do not know the laws. I'm not an attorney, and I even tell my clients that. I'll say, this is what the estate plan says. This is what it does. I can fill in what you asked me to, but I am not an attorney, so I do not give any attorney verbiage whatsoever.
Yeah, so again, just to be clear, in order to disinherit, do you have to list them as a
You have to add them.
beneficiary? So you have to add them as a beneficiary first, and
Right
then,
here,
yep, and then disinherit them.
and then disinherit. Yes.
Okay, all right.
I have a question too. Talking about disinheriting, I have a person I'm working with that wants to disinherit everybody basically. He's gonna give everything to charity, and he wants to disinherit and he has like about 15 or so people in his life. Do I have to write each one down individually or so, or can we put that down just in writing?
It's I'm gonna say again, I'm not an attorney. You're not an attorney. So are these his children? Are these nieces and nephews? Are these people he's adopted? Are these people that are going to be able to try to stake a claim on
No,
his estate?
they're all like cousins and nephew. I mean, oh, they're people along what he grew up with, relatives, that kind of thing.
And I don't think that he should have to disinherit them. I think that his trust will stand for itself. I will actually run that question through our attorney. I'll ask her just to make sure, and then have it put back in an email so that you guys will have the exact answer on that. However, I don't believe that they would have any claim in it because his trust is going to specifically say where his estate is going.
Okay. Also, I had another question I meant to ask earlier, but I had a hard time getting on here. Was is the beneficiaries wise? This same guy wants to leave dollar amounts. Okay, he doesn't want to leave percentage amounts, and a lot of the monies that he has right now is not necessarily in the trust kind of thing. It's in his house that he's gonna sell when he's gone, as well as his state 403 or his deferred comp plan thing. So we've been having problems trying to get that into percentage wise. So we wanted to do it dollar wise. I've worked with I'm working with the attorney on that one. However, I just wanted to ask you if you know, is there something general we can do? Because we haven't found anything that can do that can, it must be done in percentage. It cannot be done dollar wise. Is there a way that can be done dollar wise that you might know? That's my question.
Let's go over here and look. See, you guys are making me study, which is good.
Because we all got experiences this way that we can ask you relevant questions, like stuff that's actually happening.
Right, exactly. Okay, so this is where I do my bequests. So this would be where you would put in you're saying cash.
Yes.
So this is where you would put in that upon the death of Kyler Collins, his recipient Jeff Pryor of Cookville would receive cash how much? Let's say 80. Let's see if this works. Ah, it's making us re-sign in. Crazy thing. Don't you just love that?
Of course, one of the reasons that you're finding everything that's trying to force you into percentage is because assets do not stay static. The value of a home that's going to be sold can go up and down. The value of a, of a mutual fund can go up and down. The value of a checking account can go up and down. So the reason it's trying to force you into the percentages is the variability of the amount of asset that's going to be available at the unknown future when someone passes.
Exactly. But I do have people that I've got one couple that live in Tellico Village, and he came into the marriage with money. She did not, but he raised her daughter just like his own kids. And so he also has some family money that has been inherited per stirps, and he wants from the sale of his house, he wants each one of his children, biological, to get $200,000 apiece, and then the rest of the money be split 3 ways. This is where you would do that. You would do that bequest from the sale of that property. How much is going to go to that specific person in cash? So it is doable. Did that answer the question?
Yes. Yes. That's a good answer. I didn't realize that. Thank you.
That's where you'll put any of your special bequests. If somebody has some extra land that they want to only go to their child, you'll see that a lot with mixed families. I've seen it quite a bit with mixed families, actually. He wants so much to go to the children that he feels like were his bloodline, then he still wants to give some to the kid that he raised as well. So that's one way to do that without having to split all the assets up. You can just put it from the sale of that home, like what you were saying.
Okay.
Okay, so let's continue on here. We've got the organ donation. No matter whether they fill this out or not, they're going to have to redo it when they receive the paper documents that they're going to sign. They're going to re-put this out anyway. So if they ask you questions, just tell them you're not an attorney. What do you want? It's up to them. So I don't really give a lot of personal advice. I just ask them, do you want to donate them? Which ones, to whom? Just reading it direct. Guardian selection, of course, for children. We don't have any minor children, so we can skip this section. The financial agent, I am assuming everybody understands how the financial agent works. This is the one that handles the financial side of it. Healthcare, this is the one who's going to decide whether or not you should pull the plug, don't pull the plug, give them blood, don't give them blood. This is going to be somebody that they trust with their healthcare decisions. Again, we went through the specified bequests already. Down here, this is something that you can put into the estate plan. I had a lady who wanted everybody to come to her funeral dressed for Christmas, and this is the absolute truth. She even wants Christmas music played. We said we cannot force them to do that, but this is where you can actually put in your final thoughts, put in a letter to your children. There's no force of law here, but it will tell your kids what you'd like to have done. If you've already paid for your funeral or for your burial, this is a great place to put the funeral home that you used. If you've already paid for a cremation, this is a great place to put that information as well. If you want them all to come wearing red hats, this is a place to put that. So people will come with some very interesting things. And then of course, we're going to review here, and this is where you're going to see everything that you may have missed. So we know he has no children. That's okay. Over here, we didn't put any trustees in. That's because I'm just showing you the software. But if you see that this field is missing, that's when you're going to want to go back up to your trustee selection and start adding those in. You're going to want to go back to your financial agent, add that in. Anything that's in red shows that you've missed something. So you're going to review all of your errors and fix them. And when you're done,
Question. I
yes,
don't
ma'am.
think we got the answer on the irrevocable and revocable trust.
Yes, there is a place in here, Miss Raina, that as you're going through the documents, I'm kind of going through it a little bit fast because we're kind of pressed for time. When you're going through and filling out your trust, it's going to ask you that. Let me see if I can get back to here. I've clicked on it a million times, but because this one doesn't have a we're going to find that button together. Maybe. So what it's for is it'll say, do you want to make this trust irrevocable on the passing of the first spouse? So if they're married and there's a concern, I'm so sorry about my internet, guys. And there's a concern that he's going to meet a 20-year-old and take off with her and cut his ex-wife's children out of that trust. This prevents that from happening. All right, we did this part. Let's look over here. I feel like it's in this, and you know what? The reason why it's not showing up is because he's not married. So when you're doing somebody who's single, it's not going to show an irrevocability on it because there's no sense in it. When he passes, he doesn't have a spouse that he's passing it to.
What about even if they're single, but they want to put like the house's irrevocable trust, but they want to do like other stuff like cars in the revocable part? They want to do two. Is it a separate plan, or can we say these assets are under irrevocable and these assets are revocable?
I guess I don't understand what you're saying, because if that person's passed away, his wishes and desires are going to be in his trust. No one can change it.
Well, I do a little bit more of like, adding in nursing homes. So sometimes when the house is in an irrevocable trust and somebody gets subject to a nursing home stay, it protects them more if the house is in an irrevocable trust versus a revocable trust.
Okay. All
So
right. So
that they paid for it.
that's a
And
whole
that's while
different
they're
thing.
alive.
Yeah, that's a whole different thing. But on the death of that person, that trust becomes irrevocable.
Okay.
Can
If
I
they are
mention something
wanting,
on that as well too that you mentioned about the irrevocable trust and nursing home stuff? Check
Mhm.
with your state because every state Medicaid system is different. So you cannot say, oh, you can do this, you cannot do that, etc. Because you're gonna get surprised. In our state here in Hawaii, uh, if you opened an irrevocable trust 5 years, there's that 5 year look back, they can crack your irrevocable trust open. Even though it's irrevocable, they're the only ones that can crack an irrevocable, but that's Hawaii. Other states may be different. So that's why you got to check with your state. I also been told that as well.
well, and if it's a Medicaid or a nursing home, if it's a situation like that, this might not be the right trust for them. And at that point in time, you need to speak with Randy about doing a full irrevocable trust instead of a revocable trust. I know that for a fact. We have a lady who is trying to get an irrevocable trust to preserve her Medicaid. So that might be what you're talking about,
Mhm.
is getting a
Yes.
full irrevocable trust, Raina.
So it would be, if we did that, it'd be separate.
Yeah, it would be a whole different
Yeah.
trust, and they're a
Okay.
whole different price.
Yeah.
Okay. And is that
So
on our system or is that,
that is a Randall question.
okay.
So
Got it.
that's one of them that I'm gonna jot down for him so he can review that with you, especially since you have a client that you're dealing directly with that on. I'll go ahead and put a note in for him to send you an email of what to do in that specific situation.
And when to do an irrevocable trust.
Yes, yes, there are times when you're
Mhm.
dealing with nursing homes, Medicaid, things like that. It's a little bit different.
Thank you.
When I have a question, in the second meeting, when the client comes to your office, do you go over all these tabs one by one and kind of like
I do.
have them?
I sit down before they sign their trust. As they're doing it, I show them how to read their trust. I open it. I show them pretty much the summary, how to find anything that they're looking for, and we go over it. And I'll say, now you chose that Jeff was going to be your beneficiary. This shows Jeff, and this has got his birthday and his phone number, blah, 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 blah. This is what's going to happen if something happens to Jeff. I show them, I go through their trust with them. Yes, you want to do your due diligence. Make
Tab
sure
by
that they
tab,
understand.
re-review, and then print it, and then you have notarized to be notarized, right?
I usually
Thank you.
have it printed right there because they've reviewed it before they got to my office.
Because they got it in the email, right?
Yes, they can log into their trust anytime. And so when I'm sure that they're coming into close, we have already reviewed their trust. And then I'm going to show them how to read their trust. We're going to go through it. We're going to read the trust together. Some of the other documents I recommend printing is how to do it. This has got what you're going to do for your family tree. This is the entire agenda that you're going to go through when you first sit down with your client. And so this is an important piece of paper to have with you. Another one, I like this because this is their interview certificate. It tells them what they've named their trust. And so that's a big deal too. You want to make sure that they know the name of their trust and the date of the trust. And then you're going to use that when you go to get your deed done. You're going to use that the name that they're going to put on their trust, the date of their trust, and all of that information. And I also recommend always having a credit card agreement because you're also going to be running a separate credit card. Do you want to have to run their credit card for their trust and call them back to get the same credit card to run it for their deeds? It's best just to go ahead and have this filled out when you know that they're going to get the trust. Fill this out, put it in their file so that you have a paper copy of what you might need as you're processing the trust, writing the trust. So do your due diligence, make sure that you have your full confidential done. Ask the health questions. This is business for you. It's business for you later because we have got some fantastic long-term care plans. If you're working with Simplicity Minneapolis, the long-term care plans that we've been talking about are fantastic. That's something that a lot of people have not been able to take care of. So there's an extra back end for you right there.
Could you email us those forms when?
They're
Please?
in family
Here in the
estate
form.
docs. Let me show you where they're at. So We're on a 14-day free trial right now. Let me go into my personal one that it's already signed me out of. In your documents, you're gonna find, it's 4 o'clock, guys. I know if you have to get off, I understand. You're gonna find all of your paperwork right here under forms. This is your credit card authorization, your client signing guide, the data entry authorization form, the client interview form, every single bit of this. This right here, the user agreement, this is another important document. And then this is a copy of your EULA. This is one of those forms that you want to have printed and leave with everybody you sell a trust to. This is
In the
important.
first meeting, all these forms are in the first meetings.
Yes, you're going to do your confidential when you sit down with them. You're going to, if you sell the trust, you're going to write down their trust name, their interview date, if it's 1 grantor or 2 grantors, and then of course the name of their trust. So yes, this is important paperwork to have. And then the family tree, this telling you what the agenda is going to be, you can actually set it in front of them and they'll literally remind you if you missed a step. They'll be like, oh wait, you didn't review our health and income on page 2. So it just reminds you what you want to do when you're going through it. Click on forms, go through here, get familiar with the forms. If there's any that you can't find or you want that's not on here, this is the interview certification I just told you about. Literally printed it right off of this website. This is the same thing. Let's go over here. This is your 2 grantors if you have a married person. This is your 1 grantor for a single person. Literally click on it. It's going to download this and there it is. That's our client information. Trust provisions. You can go through and just exactly like that.
Quick question. So once we have this notarized, does that make it legal or do they need to put the trust also with the court?
Okay, so once the trust is notarized, we are going to get a little bit further into that. This specific one until 4 o'clock was just about how to fill out
Okay.
family estate docs. I'm gonna have Randall do a follow-up on this and tell you exactly what happens to the trust after it's notarized. When you receive that deed back from, if you use Courtney, like when I get a deed back from Courtney, I have the family come in and sign the quitclaim, and then it's sent to that county
Mhm.
where the property resides, or where they reside, or where the property exists. And that is when the property is recorded in the name of the deed, or in the name of the trust. And then they're going to send you, or your client, I always ask them to send it to me. I put a self-addressed stamped envelope inside of the envelope so that I get the documents first. And then when I get their deed back showing that it's in the name of the trust, that's when I make another appointment with them and I can follow up with long-term care, a back-end sale, life insurance, moving money from a 401k into an annuity, things of that nature. So that's your back end right there. So I always recommend you get a hold of those documents so you can call them, and that's another appointment. I just got your deed back. You know, when's a good time for me to meet with you and bring your deed out, and we'll go over some options that I found for you, showing you a little bit about, you know, your estate plan. And then you
Now
can,
go ahead, I'm sorry.
and that
Now
was
the
it.
deed, is the deed just for paid for properties or can you make it just for paid for properties or can you change the name of the deed if they still have a mortgage on the property?
You don't have to change the name of the deed. That is still their property, even if they have a mortgage on it. The mortgage company can definitely come take it if they don't pay for it, and it will come right out of that trust. So they want to
Mhm.
continue to pay their mortgage. They can pay their taxes through the name of the trust if they want to. Some people will actually open up a checking account in the name of their trust, so that when they make a check for their property taxes or for their insurance, when it comes to the deeded property that's in the trust, they're
Mhm.
gonna use that that account to pay those bills.
So does that deed software, because I think when I went on it, does that deed software still work for houses that have
Deedworks?
mortgages on it? Yeah.
Yes, absolutely.
Okay.
My house has a mortgage on it and I've already put it in my trust. I've worked on that this last week, actually. So that is
Okay.
something you're going to do because they still own that property, even
Mhm.
though they're paying a mortgage on it.
Got it. And they're able to like still get loans against the properties, refinance and all that stuff.
Absolutely.
Okay. All right.
Absolutely. Yeah, one has nothing to do with the other.
Okay. All right. Just want to make sure.
All right. Yeah, no problem. I love the questions. I love that we've been able to kind of sort out a lot of different things that people have had questions about.
I have
Joseph,
another
did you have a
question.
question?
Yeah, I have a question again. You know when you have the signing, right? You have people come to your office, okay? And are their clients responsible for their witnesses? Who's
Okay,
responsible
you
to make
want
sure
them
the
to be,
witnesses are there?
you want your clients to bring their own witnesses because that's 2 new suspects for you.
Okay,
Okay? When they're sitting there watching you do all this for them, and you're like, oh, as soon as you're done, have you got yours taken care of yet? You've got a brand new client right there, and they just watch their friend do it. And that just builds a lot of credibility for you. So I always suggest have them bring their own witnesses. If they cannot provide witnesses under any way whatsoever, they just don't have any friends, they don't have any family members that can come and be a witness, then yes, you can provide the witnesses for them.
because what I've done was gone to the banks, and because of the notary is there as well too, and it's free, right? Because it's their bank account kind of thing. So I've gone there and then also got the witnesses that way, but I found it's hard to get them as a, referral kind of thing when you're doing it that way.
Yeah, it really is. Several of us have already got our notaries here so that we can help each other out, notarize for each other or be witnesses if needed. But for the most part, you're kind of stabbing yourself in the foot if you're going to be if you're going to have someone else come and be a witness for them and not have them bring their own. So do your due diligence and try to get them to bring their own witness.
Okay.
Who's
And
allowed not, oh, sorry. Go ahead.
the other question I had was financial agents. The financial agents, right? There's 3, whereas like the healthcare, there's 2. Why is it that way?
Well, I don't exactly know why the attorneys did it like that. I'm going to assume that if something happened to your financial agent trustee, that the doctors would still take care of you either way. Where with financial, if something happened to your successor, the banks are not going to take care of you. You're going to want to make sure you have
Yeah.
somebody to take care of the financial side. That's the only, I mean, that I could be wrong on that, but that's another question that we'll revisit later. But I do feel like that would make a little bit of sense,
Because I put the trustor, I guess, as the financial one on top, and then put his thing on there to protect him. But then as I've gotten more into this, I found that that's why you have the advanced directives, where you have the 2 doctors first. So you don't need to put the trustor as the financial agent head to begin with because of the 2 doctors. That's why I kind of
See,
wondered
you
why this
figured it
is
out
in.
yourself.
Well,
You just
kind of.
wanted to see what I knew.
Yeah, I just want to see what you do. I'm curious on that part.
I hear ya. I hear ya. And so generating docs, let me show you guys how to do this really quick. So when you click on your eVault, this is where you're going to generate your documents. You're going to go to your document vault. All right, so it may not let me generate things until it's purchased. See how it says I have to purchase to activate it? So after this is purchased, you're going to start with your revocable living trust and you're going to generate the document. And then it's going to populate. Well, first it's going to try to make me purchase it. Then it's going to populate right here in the vault. And then you can click right on the generated document and print it. And you're going to do that for the revocable living trust, the certificate of trust, the last will and testament, the financial power of attorney, the healthcare power of attorney, the living will and advance directives, and of course your funding kit. This is where you're going to be able to go put other assets in. You can put in your deeds here. You can click each one of these and it will walk them along right through how to do each property, vehicles, boats. You just click on these right here and that will put everything into the document vault for them. And then anytime they need it, they can just always click on their vault and it'll have all of their stuff in it. And it'll be a list right here with their living will, with their financial. Everything that you print will be a snapshot right here that you can click on at any point in time and print right out of here. You want to make them an extra copy of their certificate of trust. And I like to make an extra copy of their healthcare power of attorney. And I keep mine in my glove compartment of my car. If something were to happen and I had a wreck, I want them to be able to know who my healthcare power of attorney is. So it is with my personal information right in my glove box. So hopefully that unraveled a little bit, answered a few questions for you guys. We're going to do a follow-up with Randall to answer those deeper questions that you guys threw out there. And is there any other questions pretty much just about the family estate docs, paperwork that you need to have, interview questions?
For the fees, for the notary, do you ask them, do you tell them in advance it will be like $200 for notary fees on top of the $19.95 and the $350 per home for the deeds?
I don't know what you're referring to because I don't charge $200 for notary fees.
Well, I mean, there are a whole bunch of places to be signed, and each one of them is like $20 in around here, $10. So I'm just curious, how do you can talk to them about it?
We don't have that issue. I have my notary and I don't charge that.
But for those who don't have it, like how do
Go to
you
their bank. If you go to their bank, it should be free.
Okay.
Does anybody else have trouble with people wanting to charge $10 a notary?
No.
Yeah,
No,
nobody has that
I'm a
issue.
notary.
I do
Which,
my own, and like you said, I do my own, and I don't charge them for that.
yeah. No, you need to find a bank or get a friend or get your assistant to go get her notary.
Yeah. Okay.
It'd be worth
Who
the
absolutely,
investment for you.
who absolutely cannot be a witness?
A family member, someone who has interest in the trust. If you wrote the trust, you're not a witness.
Mhm.
Well, actually, you can be because you just sold them software, so you can be a witness. But
Okay.
the person who notarizes the trust cannot be a witness. So you don't want your notary to be, which is why I was thinking I couldn't, because I'm typically the notary. But yes, if I was not notarizing it, I could be a witness.
Thank you.
So if we don't
Thank
have
you
any
so
more,
much. Thank you so
you bet.
much.
Perfect. Awesome. Thank you, Raina. So if we have any more questions, shoot me an email. Like I said, we're going to do a follow-up on this. And if there's any paperwork that I've shown you that you want or you can't find on estate docs, let me know and I'll email that to you as well. But I keep all of mine in a manila folder and that way I can just pull it right out, take care of it, and then I put their name on it. And I have a printout of the EULA and I leave this with them after they purchase their software. That way, this protects you, protects them, and explains exactly what their software is, that they can't refill it out with somebody else's name on it, regenerate documents, they can't sell it. This gives them their rights under the software and it protects you as well. So that they don't think you're an attorney, you basically sold them software. Okay? And
What
then
is
I
your
just put it
email?
right here. Huh?
What is your email?
My email is wynncollins@outlook.com. That's Wynn Collins at Outlook.
Thank you.
Okay. And so I have one of these with me all the time with everything I need in it. So if I do pick up a new client, all I have to do is pull this out, put their name on it, and I have it. Super easy. It's already pre-done and takes a little bit of stress off. Does anybody else have any other questions I can answer before I let you go? All right. It has been great. It was great to see everybody's faces, and I will see y'all next time. Go
Thank
sell
you.
some trusts.
Thanks so much, Wynn.
Thank you very much. Great information.
Awesome.
Well done, Wynn.
Have a great week. Thanks, guys. Thanks, Tony.
Yeah.
Bye, Eddie. Bye,
Bye.
Felicia.
Bye.
Bye, Ed.